Now back to the show. This is AM 650's The Law Show.
Welcome back to the program. Red Robinson coming up at noon. Rehabilitation and personal injury, the subject of this morning's program, with our guests Scott Stanley and Diana Robertson from Murphy Batista LLP. We're talking about rehabilitation, personal injuries, the government's right to deprive individuals of the right to drive based on certain requirements and so on. But Scott, I got to ask you this. You know, we see it in the paper all the time. Somebody is busted for speeding or drinking and driving, and then you read down 3 paragraphs, and it turns out this guy has been through the revolving door of the court system. He's a repeat offender with a dozen convictions for speeding or misbehaving, and the government continues to allow this person to operate a motor vehicle. And yet, if you're diagnosed with a disease that they're not terribly sure of, and there might be a little if to it, then they'll happily pull the license of people before even thinking twice about it. So how come it's so easy to deprive a person who may be medically compromised, and the guy who continues to be a repeat offender continues to get driving permission to go out and do it again?
Well, I mean, my views on this, I look at it 2 ways, right? Because I mean, driving is a privilege, right? And I see a lot of consequences. The irony of it is that a lot of my clients that end up needing driver rehab are there because of at the hands of a bad driver. Okay. And often they're a recidivist, a speeder, drinker, and driver. And I'm always shocked, Sterling, that when not always, but often is the case when there's a really, really bad, reckless car accident, that's not the first behavior for that person. Right. It's usually a long list of behaviors. And I'm always shocked. I just did a case recently where this fellow had a long, long list of driving offenses, speeding. And that's exactly what happened here. He probably had 9 or 10 convictions, but yet he still had a license. And it baffles my mind that efforts aren't made to impose restrictions on those people, whereas the government from time to time will place arbitrary restrictions on people that are probably able to drive just fine.
But we seem to not take that stuff seriously. I'm thinking of a television commercial that I know you've both seen. It's a guy in some kind of whiz-bang little sports car, and he keeps getting pulled over and handed speeding tickets by cops, and ultimately they show 2 or 3 sequences of him getting handed a ticket and rolling his eyes, and then the graphic comes up and the voiceover comes up with, you think you might want to consider a slightly less fast vehicle or something. I mean, it's a commercial for a car company. And the setup is the guy's a recidivist speeder. But that's okay. It's even kind of funny and cute.
Well,
we have a high tolerance for this sort of stuff.
Well, I think our tolerance is too high. I mean, the government, the superintendent does have the ability to pull a license if there's been accumulation of offenses. But I rarely see it. I rarely see it.
Diana, what is Drive Able?
It's an assessment for individuals with cognitive issues. It was developed out of the University of Alberta by Dr. Dobbs, and
so cognitive issues would
dementia,
probably
Alzheimer's type issues,
as opposed to maybe a brain injured person from a traumatic event.
There has been some expansion of the testing. I think it's the hope of that organization to expand it to brain injured individuals. Okay. My opinion is that it's not applicable to individuals with brain injury.
So now we're dealing with dementia patients, essentially.
Yeah, okay. I would say so. So it has been embraced by the Office of Superintendent of Motor Vehicles as an opportunity to screen and take people off the road with dementia. Okay. And in that respect, that's a good thing.
I don't think anybody listening here is going to go, oh well, that's really wrong. Of course, there are conditions under which people shouldn't be driving.
Sure, and as Scott said, driving is a privilege, and I totally agree with that. Mm-hmm. I think the thing is, though, it's the same issue that came up when we were talking earlier about that Grismer case. There's a balance, right? I mean, the government's goal is to minimize our risk to the public, which is great. But they're also looking at numbers, and they're also, looking at the financial implications of testing a lot of people. Right. So, in my experience, they're kind of looking for the magic bullet, the quick, easy, cost-effective tool that's going to answer their questions.
Okay.
But in my experience, driver rehab is complex. And again, it goes back to that individualized assessment. And that can be a problem when you utilize a tool that is I won't say canned, but that's people go in front of a computer screen for the drive-able assessment, and then based on that, their results on the computer testing, that's sent off to the University of Alberta. It's scored, and then the decision is drive or not drive.
I see. So as a lawyer, are you able to challenge the testing process and the score if the person flunked the test, for lack of a better word, Scott, and was forced to give up his or her license? Can they call you up and go, wait just a cotton pick a minute, I don't believe my score?
Sure. I mean, lawyers, the creativity of the lawyer knows no bounds when you're trying to fight and challenge things, right? But I think the reality of it is that that would be a tough row to hoe.
Okay.
Yeah. Though I have had some experience with more kind of human rights lawyers and some lawyers that I know who have then gone back to the OSMV to challenge that on behalf of individuals. And then those people, there have been some changes. Again, that's where, lawyers, I'm so impressed that the law can affect policy. They've been able to go back and have a bit of a pushback to the OSMV and say, no, you actually have to then take this person out for a road test behind the wheel. You can't then just fail them and take away their opportunity to individually assess them just based on this computer testing. So then the OSMV didn't kind of pulled back a little bit, and then those individuals have been given the opportunity for a behind-the-wheel assessment as well.
So as lawyers, you're able to influence public policy not by getting elected to or running for office, but by creating court cases in which decisions now stand as precedents and which then form public policy.
I don't think the public appreciates that the court system is a form of government. It's lost on a lot of people.
Right.
Because it's a very powerful form of government.
Right, because when you go into a trial situation, and you do that all the time, Scott, you're constantly citing case law and using examples of previous decisions. Are the judges bound by those decisions? If you go, look, in exactly a similar case to the one you're looking at right now, Your Honor, the previous judge found this to be the case. Is the judge bound by that decision?
Yeah, there's a doctrine of stare decisis, which is, basically legal precedent. And so if it depends, for example, in British Columbia, we're not bound by law from Saskatchewan.
Okay.
But we're bound by law that comes from the Supreme Court of Canada via Ottawa. We are bound, judges are bound by precedent. For example, if there was something similar that the Saskatchewan Court of Appeal did, it wouldn't be binding on our courts, but it would be fairly influential.
Right.
And it would be something they'd want to refer themselves to, no doubt, before rendering their own decision. But we're bound by what our highest court here is the Court of Appeal, Supreme Court.
Right. And Diana, this is going back to a previous chat with you. This is one of the reasons you changed professions from occupational therapy to the law, because you saw the law and the legal profession as a way of influencing and, in fact, in some cases, actually changing government policy.
Absolutely. I didn't realize, I think, early on in my career as an occupational therapist, that policy is driven by the legal cases. I think that unfortunately, clinicians, therapists, people in the medical field, we may have the research, we may have the experience behind us, but policy is driven by other factors.
Right.
And so for me as a therapist, I just feel like I'm able to influence the bigger picture now as a lawyer than I was ever able to do as a clinician.
And Scott, I guess with ICBC too, being an agency of government, a Crown corporation, some of the legal actions, and you've certainly been involved with your share against ICBC over the years, certainly that has caused them in some ways to change their modus operandi.
I don't know if it does or not. I don't know what motivates ICBC, and I guess if the minute I figure that out, I'll retire because I'll have I'll have found my Rosetta Stone.
Okay.
But definitely governments do respond to what happens in the courts. We see examples of that through, how we regulate safe blood products, asbestos, seatbelts, things like that. So a lot of times when government the good thing about the common law and the law of negligence is it doesn't require politicians to do anything.
Right.
The law's already there to protect us. And a lot of times when politicians do get around to enacting laws, it's really a codification of what the law of negligence or other common law laws have already told us ought to be done.
Right. I want to we need to take a break, and we've got our last segment. I want to talk about a spectacular brain injury case that you were involved in. It took many years. But before we go to the break, I just wanted to ask about the whole matter of the onus on the client in the situation to present. What I'm trying to ask, I suppose, is how much responsibility do you have to the client as you're trying to influence policy? If you're I'm going to change the world and I'm going to change the way the government does business, then you're not really acting in the best interest of your client. It's a happy coincidence. That's what I'm after.
Yeah.
When your client is served and public policy is changed as a result of that. That's the best of all possible worlds, isn't it?
Unless your client's given you a very clear mandate to pursue something to affect public policy or change, your first interests are to your client.
Right, right. And it is a lovely coincidence when it goes to a broader base than that, right?
It is indeed.
Okay, this is The Law Show on AM 650. A really interesting case to tell you about when we come back with our guests, Scott Stanley and Diana Robertson, personal injury lawyers with Murphy Battista LLP. Online, by the way, you can check them out at murphybattista.com. And we'll be back after this break.
This is AM 650's The Law Show. There's more of the show still ahead.